Good afternoon. The 261st District Court is now in session. Judge Daniela De Seta presiding.
Good afternoon, everyone. I'll wait till everyone gets on. Remind you that you are in a virtual courtroom without a record, and we do request that you treat this as if you were in the physical courtroom, meaning the same rules of decorum are going to apply, although you will address the court from a seated position. With that being said, I also want to talk about what the emergency court does and doesn't do. This is, again, there's not a court reporter here. This is not an evidentiary hearing. This is treated more as an appointment. So there is not unlimited time. There's going to be no more than approximately 20 minutes total for this. This is the consideration of a TRO, and the court, if it grants it, will be giving you a setting for a TI where a full hearing, an evidentiary hearing, could be set and heard as appropriate. With that being said, let's have announcements, and then we can get started with Mr. Alshire.
Yes, Your Honor. My name is Bill Alshire. I represent the plaintiffs, and I have with me co-counsel and plaintiff Bill Bunch. We are ready.
I see Mr. Bunch. Mr. Richards is also here.
Yes, Your Honor. I represent the mayor and the city council of the city of Austin, and with me is my paralegal, Karina Esparza, who will be assisting me, but she will not be speaking.
All right. Thank you. Good afternoon. All right, Mr. Alshire, and help me with pronunciation again. Alshire or Alshire?
Alshire.
Got it.
Thank you.
All right, you may proceed.
That we sent this afternoon about 1:15 with a proposed order and our case authorities.
I do not see you anymore. Can you turn on your video?
Sorry, Your Honor.
There we go. I have received everything that was sent.
You have? Okay.
Yes.
Thank you. Your Honor, I may be one of the only attorneys practicing in this area of law that has also had to comply with the Open Meetings Act for the 12 years that I was Travis County judge. But I'm also one just among many who are passionate about the need for transparency in government, including my clients in this case. As a factual matter, it is undisputed that the TOMA meeting notice at issue in this case regarding the charter amendments just said ordering a special election for the purpose of submitting proposed charter amendments to the voters. And that broad language was buried in the middle of a full agenda item, number 12 on the August 14th meeting of the City Council. The adequacy of that notice is a matter of law for the court to decide. Telling the public that the council will consider amending the city charter is on its face inadequate public notice of the subject to be deliberated without listing the amendments in the notice. It is tantamount to the council saying that they will consider amending the city code of ordinances in a regular meeting instead of listing the ordinances in the meeting notice that they will actually consider amending. By such wording, the public is not given a clue what substantive changes the council will deliberate. The term city charter is a category of topics or subjects. It is not a single subject as TOMA requires to be stated on the notice. Our argument that the topic of each proposed charter amendment should have been separately listed on the meeting notice as a subject is supported by the statutory requirements specific to charter amendments. I provided Your Honor a copy of Texas Local Government Code section 9.004D and E that in relation to charter amendment elections, an amendment may not contain more than one subject, and that each amendment must be listed separately on the ballot so that voters can vote for or against each amendment. Ironically, on August the 14th, the council voted separately on each charter amendment, even though they had lumped all of those for being charter agenda item. I don't know why my video keeps going off. I apologize. Okay.
We have you back. Thank you.
Okay. The Austin Council does know how to properly post charter amendment election items on the agenda because they did so for the last charter amendment election held on May 1st, 2021. For the council meeting on February the 9th, 2021, when they ordered that election, the meeting notice lists each of the 5 charter amendments and petition ordinances as separate agenda items and gives a short explanation of the item that comports and that comported with TOMA. I provided you, Your Honor, a copy of those agenda items from the February 29th meeting. As this court may remember from the recent case that last heard on August the 7th, 2024 by SOS against the City of Austin for TOMA violations, TOMA Section 551.007 requires the council to give the public a reasonable amount of time to speak to council on each agenda item. Because it is undisputed that on both July the 18th, 24 and August the 14th, 24, the council lumped all the charter amendments into one agenda item, allowing only 3 minutes to speak on all of the amendments together, the council again violated Section 551.007, but just used a new twist, improperly lumping agenda subjects together under one item to try to get around compliance with Section 551.007. They weren't necessarily in direct contempt of this court's order. They just tried to do a soft shoe dance around it. This is the second reason the council's approval of the election ordinance that we've cited in our pleadings for sections 2 through 15, just the charter amendments, should be eventually reversed and declared void and then temporarily enjoined from proceeding. Now, the basic rule of law on the adequacy of public notice under TOMA is well summarized in the case that I've provided to you in the City of Laredo v. Escamilla. In that case, they not only lay out the rule, but they cite to most of the other cases that are on point about the adequacy of written notice. And the notice provided by the governmental body must be sufficiently specific to alert the general public to the topics to be considered at the upcoming meeting. And courts must be careful to ensure that the notice serves the core purpose of the act. General notice in some cases is considered substantial compliance with the statute, even though the notice is not as specific as it could be. The notice must be more specific, the court said, if the public has a special interest in the topic under discussion. So if the contents of a notice are undisputed, its adequacy is a question of law. The provisions of TOMA are mandatory and are liberally construed in favor of open government. If a governmental body violates TOMA, any actions taken by the body are voidable. Now, in Cox Enterprises, the Texas Supreme Court kind of reemphasized the point, and this was in 1986. Our prior judgments, the court said, should have served as notice to all public bodies that the Open Meetings Act requires a full disclosure of the subject matter of the meetings. The act is intended to safeguard the public's interest in knowing the workings of its governmental bodies. The public body's willingness to comply with the Open Meetings Act should be such that the citizens of Texas will not be compelled to resort to the courts to assure that a public body has complied with its statutory duty, unquote. Despite just losing a TOMA case in this court over the same issues earlier this month, it does not appear that the City of Austin will voluntarily, without court intervention, comply with TOMA. Now, on the issue of the temporary relief we've requested, in the context of TOMA, the plaintiffs qualify for the TRO in that if the city is allowed to continue with the election, the city's TOMA violations may not be adjudicated due to the short time frame we have left us. But we're in this situation because the Austin City Council, after starting the charter review process in March of 2023, decided to wait to almost the last minute, waited to August the 14th with a statutory deadline of August the 19th to call the election to take final action to place the charter amendments on the ballot. And without final action by the council, a TOMA lawsuit was not ripe. Surely it cannot be the law that a governmental body can delay action, then violate the Texas Open Meetings Act with impunity because they left too little time for their actions to be challenged and stopped as TOMA provides. That's why we need immediate, even if temporary, relief. An example of temporary relief being granted in a TOMA case is in the Finley v. City of Dallas case that I gave you. That was a federal case, but they discussed the element of our TRO of irreparable harm and found irreparable harm was caused by the loss of the TOMA. Now, one last point. We found out yesterday from the Hayes and Williamson County elections offices that their deadline to finalize the ballot programming is next Friday, August the 30th. Believe me, I'm shocked to know that now. Therefore, we are in need of a quick decision. We sincerely want your Honor's opinion of the law and a TRO decision on the record, even if procedurally we are now required to seek an emergency mandamus from the Supreme Court, given the shorter time frame in which this must be decided. I'd be glad to answer any questions or clarify anything for Your Honor.
All right, thank you. Mr. Richards. And then just, you're on mute, but as a reminder, we are not on the record. You know, you mentioned you want a ruling on the record. We are not on the record, as I mentioned at the very beginning, what the purpose is of the emergency duty court and how it functions. So I just want to make sure to address that. And with that being said, Mr. Alshire, you can put yourself on mute so that I can hear Mr. Richards now.
May Ms. Esparza be permitted to share her screen, Your Honor?
Yes, thank you.
Thank you, Your Honor. As an introduction, the TRO should be denied for the following reasons, which is slide number 1. The Texas Supreme Court, Karina, can you go forward one? Says that the courts lack authority to enjoin an election. Also, there was no TOMA violation. And then if the court could enjoin the election, it should not, because a TOMA violation does not require the invalidation of the ordinance. The TRO that is requested would reverse the status quo. The plaintiffs have no probable right to relief because there's no TOMA violation, and plaintiffs have no imminent irreparable harm, and balancing the equities favors the rights of voters to cast their ballots. We can go to the next slide, Karina. This is the plaintiff's original petition, and we're going to go on the next slide to paragraph 22, which is the application for a temporary restraining order, which clearly states that they asked the court to issue a temporary restraining order against the city from proceeding with an election. And so it's clear that the requested relief is an injunction prohibiting an election. If we can go to the next slide. This is from the Texas Supreme Court in 2022, in re Canoyan. The most fundamental individual liberty of our people is the right of each to participate in self-government. The right to vote makes self-government possible and undergirds the premise that government has the consent of the governed. So the requested TRO is to prevent the entirety of the city of Austin electorate from voting, which is heavily weighed in the equities against any kind of injunctive relief. And as we'll see in the next slide, the Supreme Court has made it clear that that's not permitted. So this is a 1949 Texas Supreme Court case that was about an Austin City Council election. And this is the Supreme Court saying that the court has adopted the view that it is beyond the power of a court of equity to enjoin an election or any incident to it, although the election may be called without authority and therefore absolutely void. And that authority is still good law, Your Honor, as I'll demonstrate with our next slide, which is Blum versus Lanier, which is 1999, Texas Supreme Court, which cited to the 1949 Austin versus Thompson opinion. And this was an election to amend the city charter. So similar to the case that we're talking about today, the plaintiff attempted to enjoin the city from using allegedly misleading language on the ballot. And the Supreme Court said, it is well settled that separation of powers and the judiciary's deference to the legislative branch require that judicial power not be invoked to interfere with the elective process. And then a further case law that is more recent even still is the In re Morris case, Texas Supreme Court from last year, which also cites to that 1949 Texas Supreme Court Austin versus Thompson case. And this was another voter challenge as to a proposed charter amendment, arguing that it violated state law. Again, the Supreme Court said it is well settled that judicial power not be invoked to interfere with the elective process. Now, there's more slides on this particular case. It's very recent authority. If we can go to the next slide, Karina. Historically, the court has not enjoined elections altogether, even elections called without authority and therefore absolutely void. Mr. Elsher and Mr. Bunch claim that this is being called without authority, but even if they're correct in that, the court has said in the 70 years since the legislature granted the court statutory power to address violations of the election code, they have not once used it to altogether deprive the voters of an election. And then one more slide on this is After the election is held, the courts have far more robust role to play in evaluating the results and the process by which those results were obtained. The election code provides remedies for elections tainted by fraud, illegality, or other irregularity. A party may not file such a suit until after the election is held. So these three cases stand for the proposition that the Texas Supreme Court does not allow injunctions to prevent an election. Now, if the court did have the authority to grant the injunction, we believe that the court should not, and we'll show why. This is not an emergency. There was a work session in April, a council meeting in May, a council meeting in May 30th, another council meeting on July 18th, at which Mr. Bunch quotes himself in the pleading to say, I have to see you in court again. So over a month ago, Mr. Bunch was already planning to sue the city about this. And then at the council meeting on 8/14, he appeared, and then they waited for 5 days and filed this lawsuit and claimed that it was an emergency, even though the plan was to file this suit over a month ago, which would have given us plenty of time to provide adequate briefing and evidence to the court. Now, here are the election deadlines on the next slide. So yet the 19th, the day they filed the suit, was the deadline to order the election. And then as Judge Elshire mentioned, the deadline is August 30th for Hayes and Williamson to finalize their ballot. September 5th is the deadline for the Travis County to proof their ballot. The Secretary of State recommends electronic ballot testing by September 18th, and the deadline for absentee and military ballots to be mailed is September 20th. If the court grants a TRO, none of these deadlines can be met, and so the court will have prevented a decision on the merits with a TRO that is not allowed under In re Morris. Now, I'd like to talk about what notice was available to the citizens of the city of Austin. The Cox Enterprises says that the substantial compliance is sufficient, and as long as a reader is alerted to the topic, it is not necessary to state all the consequences which may flow. Then the next line shows you what the order, what the posting said, and then what I'm going to have my paralegal switch real quick and show you online live what information was available. So this is for the August 14th, 2024 City Council budget meeting. And if we scroll down to number 12, you can see that language that we just looked at is in this and says, ordering a special election for the proposed charter amendments. And then just a couple of lines below that, there's the first document that's the backup, is the draft ordinance. And anybody who is interested in what's going to happen at this meeting has access to the entire draft ordinance, which plaintiffs obtained apparently from here and attached to their pleading. It shows the ballot language and in red line, every single change that is proposed to the charter by these charter amendments. And so there is more than adequate information available to anyone who wants to know what the city council is going to do. All right, if we can go back to the slides, Karina. So the next slide is from Texas Supreme Court in San Antonio versus Fourth Court of Appeals. And this stands for the proposition that too much information in the posting itself is just as bad as insufficient information. The city council posting for this got it right. It said the general topic, which is what is required, and then provided for those who want to go further information, all the information about what was going to be proposed for the ballot and what the changes to the charter would be. And we've just seen that. So this next argument is that the agenda was a violation of TOMA. And this is from the Texas Attorney General opinion in 1998, saying that the agenda determination is aptly relegated to local practice and procedure. And because TOMA does not specify how the city or any other organization sets its agenda. Now, if we go to the next slide, they claimed that the agenda items had to be separated into separate line items so that residents could speak on each item. But if we applied that rule to everything the city does, this would necessitate the city to grant time to every citizen to speak about each individual item included in the thousands of lines in the city budget. And this is an unreasonable proposal. So this is a perfect example of why the Attorney General relegates the agenda to the local practice, and the city's authority is to exercise how it sets its agenda. Now, there are 13 proposed amendments. The plaintiffs have not identified which of these they believe to be important. Some of them are, for example, Proposition J, which changes the requirement for municipal judges resigning to run for office to comply with the Constitution. And then Proposition M removes the affidavit requirement for filing a claim against the city to comport with the Tort Claims Act. And then Proposition N is non-substantive corrections and typographical errors. The request that 3 minutes for every citizen to speak on each of these 13 amendments is unreasonable, and an emergency hearing, which this really isn't because it was manufactured by deliberate delay, does not afford the court time or adequate information to make decisions about this. So in the next slide, there was no TOMA violation because the notice and backup documentation clearly demonstrate compliance. The agenda items are determined by the city, not by TOMA, and so that's not a violation. And because there was no TOMA violation, plaintiffs have not shown a probable right to relief, which is required for a TRO. Now, the next slide is from the Open Meetings Act Handbook of 2024, page 70 and 71, which says that even though acts in violation of TOMA are voidable, the Act does not require a court to invalidate an action taken in violation of the Act and may choose not to do so given the facts of the specific case. Given the facts of this case, which is an attempt to enjoin an election in violation of Texas Supreme Court clear precedent, the court should not invalidate the ordinance, even if the court is concerned there may have been a TOMA violation. Then another requirement for TRO is the next slide, which is that it must be to preserve the status quo, which is the last actual peaceable non-contested status which preceded the controversy. The status quo is the city adopted an election order. A TRO reverses the status quo and undoes the status quo, and therefore is not an appropriate use of the request for an application for restraining order. Next, there is no imminent harm. Mr. Bunch may prevail on the voters of Austin to reject the charter amendments at the election, in which case there is no harm to anyone for that election having proceeded. Furthermore, as pointed out in In re Morris, the election code provides for remedies for elections after the election occurs, and a party may not file the suit until after the election is held. That is the appropriate remedy if, in fact, there is some remedy for an improperly held election. And that is not imminent or irreparable and has nothing to do with what's going on this week or next week. That happens on November 5th and 6th. Finally, in balancing the equities, which the court should do in determining whether to grant a TRO in Texas disposal systems, the plaintiff had lost their municipal waste contract and knew about it for several months, and then waited until after the new contractor had spent $7 million to get ready to deliver on the contract, and then filed a TOMA claim seeking an injunction. And the Austin Court of Appeals said it was appropriate to consider the plaintiff's delay in seeking equitable relief and balancing the equities in favor of denying the requested relief. The plaintiffs planned to sue about this on July 18th, but waited until after the August 19th deadline. Finally, more importantly, with regard to the balance of the equities, again, the In re Canoyan case says the most fundamental individual liberty of our people is the right to vote. The proposed TRO deprives the citizens of the right to vote on the charter amendments, and depriving the citizens of the right to vote is contrary to the public interest, which must be weighed in the balancing of the equities. We believe it's clear that if the court actually did have authority to grant an injunction prohibiting an election, that the balance of the equities weighs heavily in allowing the voters of the city of Austin to vote on the proposed charter amendments. And so in conclusion, The Texas Supreme Court prohibits the requested injunction. There was no TOMA violation. The TRO would change the status quo, which is an improper use of the TRO. There is no emergency, and the balance of the equities favors allowing the voters to vote. Therefore, the court should deny the application for temporary restraining order. And we will provide the court with the 3 Texas Supreme Court cases that were referred to at the beginning of the presentation and a proposed order denying the application for TRO. Happy to answer any questions.
I have no questions at this time, but I will note that nothing was filed in response. And so there are no, we checked and there are no filings in response at this time, as of right now.
Agreed, Your Honor. We have only had notice of this for 2 days, and we were not aware of a requirement to file a response. We're only required, I believe, to be here at this hearing and provide Your Honor with the authorities demonstrating why the TRO should not be granted.
And
Yes, you can respond. Go ahead.
we served the city attorney's office on Monday morning as soon as we got a cause number, first of all. Secondly, we weren't provided, let me get my camera back on. We weren't provided any of this before the hearing, even though we provided ours at 1:15 this afternoon. So I'm trying to make sure that I address all the substantive complaints they had. Number one, the last peaceful event was on the 14th when they passed the ordinance, but that was in violation of TOMA. Those cases, I'm real familiar with those mandamus cases on election law, and they don't, those cases are not TOMA cases. Some of them occurred before TOMA was even set. And so what we have here is a question of whether or not TOMA is going to be enforced. If it was the city that put the election in jeopardy by violating the Open Meetings Act in order to call it. So we've asked for temporary relief. Otherwise, if the election proceeds, we're not enforcing the Public Information Act. The public not only has a right to vote, they have the right to see how the stew gets made, and part of that depends on transparency and on public notice. It is not true that Mr. Bunch could have legitimately filed a lawsuit on July the 18th or any date prior to August the 14th because it wasn't ripe. And under the open meetings case, you have to have final action for the court to then reverse. And it is voidable action.
I believe your video turned off again. There we go.
Okay. Let's see. By the way, the other thing that's mentioned in the suit I didn't mention today is that he showed the website. If he showed the first screen of the website at the city of Austin for the meeting, it would say it was a budget session. And then you have to click on that in order to get to that meeting date, and then you see it. Oh, the other thing about that you can use backup to somehow mitigate an utter failure to post the meeting requirement. They have not cited a single case that says that the meeting notice is excused for its inadequacy if the actual subject is included in backup somewhere that somebody has to go read long legalese in order to even know what the subjects were. In short, the city's assertion of incorporation of extraneous documents to cure inadequate meeting notice language would gut TOMA section 551041's notice requirement that the subject appear in the meeting notice itself. And we are not somehow being unfair to the Austin City Council. They know how to do this. They did it the last election on charter amendments, and we haven't laid down the law. I mean, it takes a little bit to see if there's someone that wants to sue and then get the petition ready and file it. So they acted on Wednesday. We tried to see if we could get signed documents, and they're not available online for some reason. And we filed that lawsuit very early Monday morning, asked for it to be expedited, and got it to everyone as quickly as we could. We also contacted this court to try to get the setting. With the only reason that we couldn't agree, the city attorney said they couldn't be ready until Thursday. We were ready. We'd be ready for Wednesday. So those, if there's other issues that Your Honor wants me to address, I'd be absolutely willing to, but I think that if we're going to enforce TOMA, you do what TOMA says is the relief, and that is that the action, they cannot continue on without it. And by the way, I'm not so sure that balancing of the interest is a criteria to be used in a TRO, but if it is, I invite you to look at the Finland case that I gave you, where that was a TOMA case involving a temporary order but in the federal court, and they did balance the interest and determined that on balance, the public is entitled to that notice, and that is worth, and it wasn't that difficult for the city to have complied. If there's any other areas or questions Your Honor wants me to address, with all of those slides flying by, I'll do my best.
I'm going to give Mr. Richards one last opportunity to address anything else, so we can wrap up.
It is the plaintiff's burden here, Your Honor, and I heard that the city had failed to present any authority for the proposition that backup documentation supplements the notice. There's also no authority from the plaintiff saying that backup documentation does not supplement the notice. Furthermore, the cases that we have cited regarding the authority of courts to enjoin elections talk specifically about alleged state statutory violations. The court was clear that that did not justify or allow an injunction of an election. And if there was a case in which a TOMA violation somehow trumped the In re Morris holding, I have no doubt we'd see it. And I have looked thoroughly through TOMA cases, and there is not one, or not one that I can find. So I believe the Texas Supreme Court's ruling on prohibition of enjoining elections applies to all statutory violations. Thank you very much, Your Honor.
Thank you. Anything else?
No, Your Honor.
All right. We're going to take just a less than 5-minute break, and I will come back with the ruling.
Thank you, Your Honor.
Thank you for your presentations.
The 261st District Court is back in session.
All right. Thank you for your patience, everyone. You can see and hear me?
Yes, Your Honor.
All right. What I am looking at, I am looking at the notice that was provided for the 14th to determine the adequacy of the notice. That's one of the first things I'm looking at. The purpose of the Open Meetings Act is openness and transparency. And the conduct that is described frustrates this purpose and makes it so that plaintiffs would suffer irreparable harm. For that reason, the ruling of the court is the following. The court finds that defendants did not provide adequate notice of counsel's August 14th, 2024 meeting, agenda item number 12, to approve the election order identified as ordinance number 2024-0814-012. The court further finds that plaintiffs will likely suffer irreparable injury because, with the imminent deadlines to prepare ballots for a November 5th, 2024 election, the ballots may be prepared and mailed before plaintiffs' claims can be adjudicated in the district court. The court is also going to find that if a temporary restraining order is not issued, an election would be held on November the 5th, 2024, on the city's charter amendments without defendants having strictly complied with the Texas Open Meetings Act, Texas Government Code Section 551007B and 551041 to allow for public testimony on such agenda items of special interest to the public and to provide sufficient notice of the subjects of any meetings pertaining thereto. Therefore, the defendants are enjoined from taking further action on or giving effects to parts 2 through and including part 15 of its ordinance number 2024-0814-012, ordering a general municipal election, a copy of which is identified as in plaintiff's exhibit attached as P1 in plaintiff's original petition for mandamus and injunctive relief application for temporary restraining order filed in this cause on August the 19th, 2024. Now, the temporary restraining order would expire on September the 5th. Next week is settlement week. apologies. It's not next week, that's settlement week, it's the week after. I am able to provide you a full evidentiary hearing on your TI hearing on the 29th. Or you may wish to agree to extend until the 12th, September the 12th. We can provide, it's going to be on the central civil docket, a 3-hour setting for your TI on September the 12th. So we're talking about short periods of time, but for the 12th, it would require your agreement because it's going to extend a little bit more than the expiration that I would typically give. So which one is it going to be?
I would have to confer with my client before agreeing to extend a TRO, Your Honor.
All right. Well, in that case, what I will do is set you for the 29th because I have some time constraints with settlement week. I can't set you on the 5th. I will set you on the 29th. And if you all can confer later, you can agree, you can send this court an extension until the 12th and we can move you to the 12th, but I'll need to know as soon as possible. The dockets are busy and full. That's going to be.
May I, Your Honor?
Yes.
On the 29th, do you have a time and will it be heard by you?
No, it's on the general civil docket. I'm the emergency court this week. I'm the duty court handling emergencies, which is why you got me.
Yeah.
So I would set this. It's going to be civil. I don't know who you're going to get, but you will find out shortly.
Is it 9 or 10? 9 or 2?
We would be setting this for 9. Again, if you confer and you want to agree to extend until the 12th, I know for sure we can fit you in on the 12th for 3 hours. Again, this is central civil docket. We have a central docket. I don't know which judge you're going to get. I just know the dates that I can provide to you given sort of the wrinkle that we have settlement week coming up. So you all confer on that. Thank you for your time and your presentation. The court will sign the order and get it entered today.
Okay, and Your Honor, may I ask Mr. Richards on the record? On the record, we're not making if he will waive the formal writ service for the TRO.
Sure, you can serve me with the order is fine.
Okay, the court will be sending it to us. Okay.
All right, well, I'm going to sign it in just a moment. Thank you all for your time, and you're dismissed from the virtual courtroom at this time. Have a good afternoon.